Welcome to Court Explainer over the festive seasons, where we are looking at the Constitution of the Republic of Kenya. We are still on Chapter 11 on devolved government. We are on Part 3 of the functions and powers of the county government. We look at functions and powers of national and county government. In Article 186, it is clearly spelled out that the functions of the national government and the functions of the county government are distinct, and they are provided for in the Constitution. And, for example, except as otherwise provided in Article 168(6), the functions and powers of the national government and the county government respectively are settled in the 4th schedule. We'll check at the 4th schedule which are the functions of government, national government, and which are the functions of the county government. Then we have a situation. There's a time Nairobi county government transferred functions to the national government under the leadership of Sonko. Remember when functions of Nairobi county were transferred to the national government, and people are raising, where does this come from? Under Article 187 of the Constitution, the Constitution allows the national government, it can agree by agreement to transfer its functions to a county, some functions. And also the county government can transfer some functions to the national government. So this is the basis on which Sonko transferred some functions to NMS, which was created by Uhuru Kenyatta's presidency. Therefore, your county can transfer some functions and give those functions to be done by the national government, or the national government can transfer those functions under Article 187. Then, Part 4, the boundaries. We have seen a dispute in Isiolo, between Isiolo and Meru. We have seen a dispute of boundaries between Kisii and Nyamira. We have seen a boundary dispute between Kajiado and Narok. We have seen quite a number of disputes of boundaries. What does the Constitution talk about the boundaries of a county government? That is in boundaries is in Article 188. The Constitution provides that the boundaries of a county may be altered only by a resolution passed by the National Assembly with the support of at least 2/3 of all the members of the County Assembly. 2, the Senate with support of at least 2/3 of all county delegations. So what does the law say? A boundary of a county is static, but if it must be altered, that motion must go to Parliament. It gets 2/3 majority vote. It goes to Senate and gets 2/3 majority. So it is almost impossible to change the boundaries of Makueni. It is almost impossible to change the boundaries of Nairobi, because you have got to get the 2 parliaments passing that resolution. The boundaries of a county may be altered to take into consideration very many other factors. There might be reasons as to why the county boundary can be altered. So those ones you have dealt with. Then how does the government, the national government and the county government work? It is called relationship between governments. Cooperation between national and county government. Under Article 189, there is a liaison committee that is formed under Article 189 that coordinates the national government and the interface between the national government and the county government. Many of Kenyans see governors always meeting the deputy president. That is pursuant to Article 189. They discuss that interface between the national government and the county government, so that all these are governments, they are serving their people. Whenever there is a dispute between the county government and the national government, Article 189 resolves those disputes. How does the national government support the county government? Article 190 provides for that the national government will allocate some funds to the county government through the Senate, and that Parliament passes it, it goes to Parliament, then they deal with the question of how that money is taken to the county government. So, national government is bound by law because it collects taxes the whole country. Under Article 190, it must take back that money back to the counties. If there is a conflict of laws between the county government bylaws and the national legislation, Article 191 provides that if there is any conflict between the laws of the county government and the national government, Article 191(2), national legislation prevails over county legislation. So if the legislation by the national parliament or senate is in conflict with the county legislation, the county legislation is inferior. So therefore, it moves on that the national laws are more important than the county laws. Suppose the county government misbehaves. Your governor has eaten everything. Can the government, the national government, take over the county government? Yes. At one time, when the Makueni governor, Professor Kivutha Kibwana, had a lot of problems in Makueni, he recommended for the national government to take over the county government of Makueni. When the issue of the Governor Kawira then in Meru, she had a lot of problems, she recommended the county government, the national government, to take over. What is the basis of that? It is now here. Article 192 talks of suspension of a county government. The President of the Republic of Kenya may suspend a county government. 1. In an emergency arising out of internal conflict or war. If there is internal conflict in your county, the President of the Republic of Kenya can suspend that county. 2. In any other exceptional circumstances. 2. A county government shall not be suspended unless an independent commission of inquiry has investigated allegations against that county. So the president will appoint an independent investigation tribunal. It will investigate, and if the allegations are justified, that investigation shall be taken to the Senate, and if the Senate approves it, the president will suspend that that county. The Senate can terminate the president's decision, and a suspension under this article shall not extend beyond a period of 90 days. Only a suspension can last for 90 days. And within 90 days, what was there must have been corrected. It says on the expiry of the provided 90 days, an election for the relevant county government shall be held. So if the president and the Senate agree to suspend your county, a new election shall be held within 90 days to bring in a new governor, to bring a new deputy governor, and to bring new MCAs. Then we have the qualifications of being a member of the county assembly. A member of the county assembly, the only qualification is purely a person who is above 18 years and a registered voter and a Kenyan. there is no academic qualification required. There was the law that talked about a degree. The courts declared that law unconstitutional. So any border guy, anybody who wants to be an MCA, there is no academic requirement to be a member of the county assembly. In Article 194, how does an MCA lose a seat? An MCA can lose a seat if he resigns. 2, if he dies. 3, and 2, resignation is in writing to the speaker. If he dies. 3, if he decides or if he is removed by parliament. What does that mean? He can be recalled by the citizens. Members of the ward can vote, call him, get signatures, take to the IBC, and the MCA will be sent home. What are the powers of the county assembly? Do you know you can be called by the county assembly, whether you are who, to appear before it? Under Article 195, the county assembly has powers to summon a witness similar to the Senate, similar to Parliament. Those summons are like summons of the High Court. If you don't go because they want to ask you questions, they will fine you and you can be arrested and be jailed for that. Then, under 196, the public participation, county assemblies, whenever they discuss the budget, they must involve the public participation. The public must be involved in those matters, and that is provided for in Article 196. And the county assembly must comply with the gender rule and the balance of diversity. The disabled must be in the county assembly, the youth must be in the county assembly, the women must be in the county assembly as pursuant to Article 197. Then the county assemblies, every time the county assembly makes their laws, they must be registered and be gazetted in the Kenya Gazette as provided for in Article 199 of the County Assemblies Act. So today we have finished the question of devolved government. We have started from all parameters of the devolved government. We have finished the county executive, that is the governor and the cabinet. We have gone to the county assembly. We have talked to the speaker. We have talked to the MCS. We've dealt with how they make their laws and how they gazette them. That marks the end of the county assemblies, the county, that is chapter 11. We shall be moving to chapter 12. What is the public finance? That is chapter 12 of the Constitution. Always remain tuned with Court Helicopter. Remember, we told you why we are doing this. In 2010, only Raila Odinga and Kibaki read the Constitution. We were told, vote yes. We voted. Raila Odinga died. Kibaki died. Now nobody can read for us. Court Helicopter now has brought it to you live. You can watch it. You can listen to it. You can read it, because Court Helicopter now brings it to you so that you understand the Constitution of Kenya. Wakili Danstan Omari from Court Helicopter News. Thank you.